Bonjour Muriel.
Bonjour. All right, I think it's time to start. So, hi, hello, everyone, and thank you for joining. I hope you're healthy and safe from wherever you're tuning in. Welcome to this first seminar series, Green Leaders in Democratic Governance, hosted by the Ash Center here at the Kennedy School and co-sponsored today by the Minda de Gunsberg Center for European Studies at Harvard. I want also to thank the sponsor that made this new series possible. My name is Muriel Rouyer. I'm a professor of political science at the University of Nantes in France and a fellow here at the Ash Center. I will be your moderator today, and I will be helped in this task by Melissa and Jahaida, who are co-moderating, co-hosting the meeting with me today. Melissa and Jahaida, can you say hi? You will be very helpful today.
Hello, everyone. I'm sorry that I don't have my camera, but I've been sneezing. I have a cold, and but I'm here for you.
Thank you. And Melissa?
Hi, everyone. Thanks for joining today.
Yeah, thank you. And Matt from the media services will also be here, and Sarah. So we get a lot of technical support, and that's really helpful for debates to go smoothly. So before I introduce the topic and our wonderful guests today, let me briefly tell you what to expect today. So first, I will go over a few housekeeping rules. Please be reminded that this event is being recorded. So we kindly ask you to turn off your mics to reduce white noise and to turn on your cameras if possible, particularly if you want to speak. We have 1 hour in our hands until 1 p.m. I will give a short introduction for 5 minutes. Then panelists will give short presentations and respond from question from the moderator for the first 40 minutes. And then we'll take questions from the audience for about 20 minutes. There will be a bit more time afterwards if you want to hang out informally and chat with our guests. So I would say about 20 minutes. So if you can, and if you are able to stay, please do so. You're most welcome. But we also understand that some people have to go and nobody will be offended. Participants can submit questions and comments via the chat function at any point throughout the event. And we'll do our best with Melissa, Jahaida, and Sarah to address some of them later in the hour. We will also save the chat and we can follow up later on with you by email. Finally, I want to thank you in advance for your patience should we experience any technical difficulties throughout the hour. So today's topic is how climate litigation sustains democracy in the US and in Europe. Allow me to clarify quickly the perspective before we start with our guests. So here at the Ash Center, we focus on challenges to democracy and concrete solutions to make it work in new or difficult circumstances. Climate change is clearly one of them, and democracies have a hard time dealing with it, particularly if they are corrupt. But not only, very progressive democracies are also literally embedded in carbon, which makes climate action and decarbonization the two major policy objectives of the Paris Agreement so difficult to implement. And both climate action and decarbonization of our societies involve hard political choices and difficult trade-offs. They create new opportunities, that's true, but they also create new inequalities between losers and winners, or winners and losers, such as the Yellow Vest movement in France, or workers of the coal or oil industry in the US. All those issues are much better off debated publicly and decided democratically rather than in obscure technocratic quarters, if we want people to understand and embrace climate action. And this is also why we are doing this new seminar series. However, it is difficult and it requires skilled democratic leadership. And some people simply give up on democracy. They would rather some form of green authoritarianism or scientific dictatorship. But some, like our guests, don't give up. On the contrary, they demand more from democracy, and by doing so, they do a hugely transformative work. I like to call them the democratic heroes of our time. Democratic because they take climate science and individual rights seriously, and by demanding more from their governments in the principled forum of courts, they give democracy a chance to adapt to climate change. They reinterpret democratic core values in light of new circumstances. And they're also heroes because, like ancient Greeks, they stand before us in the public sphere, and their courage and virtue is an example for us all, which can inspire other people, give them strength and hope in collective action and in democracy's ability to tackle this huge challenge. So today, I want to introduce you to 4 exceptionally talented individuals and their organizations. Phil Gregory is an attorney and a co-counsel to Our Children's Trust, an organization who sued the US government for climate inaction in a landmark trial, which activist Naomi Klein has called the trial of the century. With him today, Nathan Bering, one of the brave children of Oregon organized in Our Children's Trust, which gathers 21 young plaintiffs in the Juliana versus USA case, is also here today, and both will share their perspectives on this important American judicial saga. On the European side, Marjan Minnesma, a former Greenpeace campaign director, is the co-founder and director of Urgenda, a Dutch foundation aiming for a fast transition to a sustainable society. And she also has engaged in climate litigation to demand more climate action from the Dutch government. Marjan has been distinguished several times in her country, the Netherlands, and by Foreign Policy magazine as a leading global thinker. And last but not least, Mia Haugen-Chamberlain is a young board member of the organization Nature and Youth in Norway. She is in charge of oil politics in this organization, which is an environmental and youth climate activist organization. All of them have scored points in courts recently, although in very different political and legal contexts. And all of them have so much to teach us. So with no further ado, I give them the floor. Phil will speak first, then Nathan, Marjan, and Mia for 5 minutes each for a first round of presentations. Thank you. Phil?
You're muted.
Phil?
Can you hear me?
Yes, we can hear you.
Thank you for that kind introduction. I'm going to share my screen. Can you see the screen here?
Yes, we can.
Okay, so I'm going to be speaking primarily about our case Juliana versus the United States, which addresses the issues of domestic rights-based litigation and climate change. Excuse me here.
Yeah.
I'm sorry that I've got to, so what is the Juliana case? Juliana was brought by 21 young plaintiffs from around the US who are suing the federal government seeking a remedy to protect from climate change. And you'll see that our plaintiffs are from all over. Later, you'll hear from Nathan, who's in Fairbanks, Alaska. The Juliana case is science-based. And what I mean by that is the evidence that will be in court will be purely driven by what the climate scientists, economists, and other scientists are prepared to testify to. And all of our experts in Juliana are working pro bono. It's against the federal government, not against the fossil fuel industry, not against anyone else but the federal government, to halt what's state-created danger and other constitutional harms. And it seeks to enforce legal rights to a climate system capable of sustaining human life. Juliana was filed in August 2015 against the Obama administration. So this is not just a case against the Trump administration. We originally sued the Obama administration because of the federal government's affirmative conduct, and our view is that it violates the plaintiff's constitutional due process rights, because the federal government has known over decades that it is creating and controlling and perpetuating a national fossil fuel-based energy system that it knows will result in the destruction of our nation and profound harm to these young plaintiffs. The two primary theories that we're proceeding under are the public trust doctrine and constitutional protections. We have a wonderful federal judge, Judge Ann Aiken, located in Eugene, Oregon. And on November 10, 2016, just after the last US presidential election, she denied the federal government's motion to dismiss. And what she said, and what should resound with all of us, is that she had no doubt that the right to a climate system capable of sustaining human life is fundamental to a free and ordered society. And again, what she pointed out is that our complaint alleges governmental action in affirmatively and substantially damaging the climate system. So what Juliana is focused on is governmental action. I want to just give you an example of where things have gone over history. The left side of this graph starts with the Truman administration in the 40s and moves all the way up to the current administration. And you can see that the red line is the global annual mean CO2 emissions. And you can see that the US, under all the administrations, the curve is moving consistently up. The remedies we seek include a declaration of fundamental rights, an order for a remedial plan. We want to enjoin new fossil fuel activities by the federal government. And we want the court to retain jurisdiction to monitor compliance and to refine the remedy as needed. I'll stop right there because I've used my 5 minutes, but later on, in answer to one of the questions, I'm sure I'll be talking about where Juliana is right now.
Thank you very much, Phil. Nathan, your 5 minutes.
Hello, everyone. So to follow, I'm very happy to follow up right after Phil. I'm not going to show any slides because Phil was able to cover the legal side of the argument, and I'm going to take a step back and kind of give context to one example of where the youth are coming from. So in 1957, my grandparents on their honeymoon moved up to a small fishing town on the coast of Alaska, excuse me, called Homer, Alaska, and my mom was born there. And then my mom had me in Fairbanks, Alaska, which is where I am right now in my childhood bedroom that you see behind me. So that means that I am a third generation Alaskan. And Alaska as a state and the Arctic as a climate is extremely fundamental to my sense of self and how I grew up. And a lot of the kind of the cultural traditions that surround me and where I come from are dependent on the sustainability of this Arctic climate. A few of the events you may have heard of before, there's those such as the World Eskimo Indian Olympics. There's those like the Yukon Quest International Sled Dog Race, the World Ice Art Championships. And really, you know, what makes this place absolutely unique in the world and the Arctic as a whole is, you know, the cultures, the indigenous cultures, and the events that it is able to support that kind of sustain a place that makes it special. And even on a personal level, I'll just say that, you know, it's in my very blood that I cannot stand any kind of warm weather. So that's just kind of a selfish note as well, but one that I also do keep in mind. So I guess what I'll say is that, you know, when we talk about the term Arctic, Arctic has two uses in our popular culture, right? It's a geographic place. It's a region of the world, right? A region that is warming twice as fast as the rest of the United States and the rest of the world. And it's also an adjective. And so when I say I'm an Arctic person, you know, what I mean by that is that it is an intimate part of who I am. And so when I joined the case as a young plaintiff, I was only 15 years old. I am now 20. I'm now in the middle of college. So I had just been in the transition from my freshman year in high school to my sophomore year. And so I joined the case fundamentally because before joining, I had taken every single civic action you can think of in the United States that is available to someone who does not yet have the right to vote. Of course, now I have the right to vote. But what that looks like is organizing on the ground. It looks like lobbying every single individual member of both our state legislature. I did that back in 2015. And then I've been to Washington, D.C. to do the exact same thing with multiple organizations through my life. But what has been really fundamental about this case that is so different and has become so vivid in my lifetime is we are dealing with systemic harm. We're not dealing with individualized, as my lawyer would, my other lawyer, Julia Olson, would put it, we're not playing a game of whack-a-mole anymore, you know, where we see a new fossil fuel project come up and we just whack it. You know, we want to deal on a systemic level with the affirmative actions that our government has taken since long before I was born. And so I joined this case because, you know, it was the first major legal action in the United States that I had seen, that I had the opportunity to be a part of, that, you know, that really focused on the core of the problem, which was the leasing of fossil fuels on federal lands. You know, the promotion against the best known science that they've had dating back to the Johnson administration and back even to Svante Arrhenius and you know, when he discovered the greenhouse effect back in the early 1900s. So I guess I'll stop there as well, and I'll be able to answer further questions in the Q&A as well. But thank you for being here.
Thank you, Nathan. Very interesting story. Marjan from the Netherlands and Urgenda. Marjan?
Hello. Yes, maybe because I guess most people have no clue what Urgenda is.
Yes, please.
We are an organization that started at Erasmus University in Rotterdam, where I was leading the Institute for Transitions. And at a certain point of time, we had 40 books of...
please.
What? At a certain point of time, we had 40 books of PhD students, and we thought, are we changing the lives in the Netherlands with all those books? No. So we invented the urgent agenda and started real action to make happen what we thought was needed to do. So we worked to a large part on solutions. We introduced the first electrical vehicles in the Netherlands. We did the first European action on joint buying of solar panels and brought prices down with 1/3. And so we did a lot of very concrete things. And we also invented or made a plan for the Netherlands how we could become 100% sustainable energy and no emissions within, at that time, first 18 years and by now 10 years. And we are working on all the solutions that are necessary to reach that. But after so many years of working on it, I thought, are we moving quickly enough? And it was very clear that we were not moving quickly enough. So we thought, what else do we need to do? And maybe the only rational thing to do is to bring it forward to the courts, who look to the facts and don't look at what politicians say and all those things that are framed in a way that's not the truth. But if you bring it to the courts, maybe there is a way that you can show that climate change is a real big problem with enormous consequences. 1/3 of our country is below sea level, so we will really have a major problem if it goes as quickly as many scientists think it will go. So that was actually the reason, besides going on with frontrunner projects and going to the streets. So we organized the People's Climate Marches and things like that in the Netherlands. But we also decided, let's go to court. But you can't go to court at once. So we had a presentation. You here see James Hansen, you probably know. We invited him and Dutch scientists to show to the parliament that climate change is a real problem. And the Dutch government has said for 10 years in a row, we should reduce between 25 and 40% all our emissions in 2020. And we were clearly not on track. So we demanded the government to accelerate. And we sent them a letter, please go up for 40% in 2020. And then we received a letter back in which they said, we agree that it's a major problem, but we don't want to move that quickly. We don't want to be a front runner, which is really laughable if you know that we are in Europe, the laggard of Europe. We have the least renewable energy of all countries in Europe. So to say we don't want to be a front runner is kind of funny. But we had our dialogue, so we could go to court then, which we did. And it took us 3 years before we won the first one in the first district court of The Hague, where the court clearly said climate change is a very, very big problem. There is a duty of care of the government. You need to protect your citizens, and you don't have unlimited freedom to say, I don't want to move. And the court said, Urgenda wants 40%, but that's up to the politics, but the lowest level, because they had subscribed to many, many documents that they needed to do between 25 and 40% in 2020. So the court say this lowest level, that's what we guard. So you should do at least 25% in 2020. And this was based on simple tort law, civil law. So no human rights law yet. And you have to act immediately. That was also said in the verdict, which clearly the government did not do. And I think it's good to note that our government has a goal here of 49% reduction in 2030. So when we won in 2015, if you take a straight line to their own goal, what we demanded is not strange at all. It's on the line that they need to do anyways. So we're not demanding something big, high, strange, or whatsoever. We're actually helping them to reach their own goals. But they appealed to the higher court. And so, yeah, we decided if you appeal, and they had 29 grounds of appeal, we decided then we want to have one ground of appeal, because we think that it's also based on human rights law, that there is duty of care, not only because of court law. And the first judge said, because Urgenda is not a human, they cannot apply human rights law. And we had also 900 citizens as co-plaintiffs. But we said, even if we are an NGO, we can still draw upon the human rights law. We can't go to the court of human rights in the EU, but we can use this body of law. And the Hague Court of Appeal slashed all the grounds of appeal of the first court of the state, and our one ground of appeal was acknowledged. So we also won the second case, and then also based on human rights. And because that is EU law, which is of a higher order, we won this based on the duty of care of the human rights law. But
okay, Marjan, your time is up, but and also your mic has could we work on Marjan's mic? People cannot hear you that well. You're a bit broken. Right. So yeah, we understand the duty of care is a very fundamental element of your strategy, and the one that gave you ground to act, correct?
Yeah, that's a very important element. Can I add a little bit more?
You have 30 seconds.
Okay. Well, I think we also won at the highest court 2 years later. So the Supreme Court admitted. And what we did is we made a plan together with 800 organizations how the government could still reach the 25% reduction in 2020. So we offered them a way out, and we said we can also help you to reach the goal. And they accepted that. So in the very end, they decided to close 1 or 2 coal-fired power plants, reduce their capacity to a maximum of 25%, and 30 of the 54 measures that we invented will be carried out to an amount of 3 billion euros. So in the end, they will be able to do the 25% reduction. And I think that's, well, we're very happy with that.
All right, thank you very, very much, Marjan. This is very enlightening and quite different from the US case. Mia, can you step in, Mia, for your 5 minutes?
Yes, I can. Hello, everyone. My name is Haugen-Chamberlain. I'm 21 years old, and as was mentioned, I'm in the Central Board of Nature and Youth. I'm going to try to share my screen here just to show you a few slides. So this is kind of a picture illustrating Nature and Youth. It's at our summer camp. We're an environmental organization for youth between the ages of 13 and 25 years old in Norway. So we kind of have this saying, which is that we don't trust anyone over 25, especially not with the climate. So we're suing the Norwegian state, and I just have to say that when Urgenda won in the High Court, that was really inspiring for us. We kind of had a little celebration that day. But we're suing on different grounds. We're suing the state on constitutional grounds and against specific oil projects. I'll talk a bit more about that afterwards. I joined climate action or climate activism when I was 15 years old. And I did so because I had this like physical, real anxiety when people talked about climate issues and environmental issues, because it just seemed like this massive crisis that everyone was talking about, especially grown-ups and politicians, but it didn't really seem like anyone was doing anything. Grown-ups weren't really changing the way they were living, and politicians weren't changing policies in order to save the future of me and my generation. So I joined Nature and Youth. I've been lucky to be able to work with climate litigation there, and kind of cured my anxiety, because climate litigation is the exact opposite of what I was just describing. It's actually doing something very active as kind of a last resort, just like Nathan was talking about, in order to save our climate. Oh, I have no idea how to go on. Oh, there we go. So we're suing the state. We did so in 2016 together with Greenpeace Nordic. And we're suing the state on constitutional grounds because the Norwegian constitution says that everyone has a right to a livable environment, and the state has to secure this right. So it kind of gives the state direct responsibility for saving the climate and doing stuff actively in order to do so. Whilst in 2016, the Norwegian government gave out oil licenses in further north than ever before in the Arctic. And this was doing the exact opposite, because not only is the Arctic very vulnerable to climate change, but it's also some of the most productive sea areas in the world, which Norway have this responsibility for. Just here on the picture, you can see a picture of an oil platform. It's the one that's the furthest north now, I think, and some whales swimming right by, and it kind of describes the area. So even though this is a climate litigation case, we want to stop these oil drillings, mostly because Norway exports millions of tons of oil every year, which we do not take the responsibility for the emissions they cause. It's also a case that's about nature, because we're entirely dependent on the nature in the Arctic. We've been through 2 rounds of court. We've been to the district court and the Court of Appeals. I just learned those 2 words in English in order to say that. And we just a few weeks ago got the amazing news that we're going to the Supreme Court. So we're very excited about that. We have not won our rounds in court. We've had some big victories in court, but the court agrees with us that that we do have a right to the livable environment, and that right is secured in the Constitution, and that the state has to do more. However, we've kind of lost on the part where we want these oil licenses to be taken back, if that makes sense. But we're hopeful for the next round, because the Supreme Court might be able to take some more gutsy decisions than the Court of Appeals. This is us in front of the Court of Appeals. I've almost used up my time, so I just want to say thank you for letting me speak here, and I really hope that you have some questions for me afterwards in the audience, because I probably didn't say nearly enough.
All right, thank you very, very much, all of you, and Mia, lastly. So I just want to point out for the audience a few important aspects of those presentations. The first one is the systemic aspect mentioned by Phil, as opposed to some, maybe attacks of certain projects mentioned by Nathan. However, one thing we need to remember is that those four people operate in very different political systems, very different judicial systems with different types of judges. So one question and one point I want to highlight for our participants is that it's quite important that in the law somewhere there be someone who is disposed to and receptive to climate science. And what is beautiful is that in the Juliana versus USA case, judges have been quite receptive, and in particular, this judge mentioned by Phil have been quite receptive to climate science. It's not always the case, and there are doubts as to the composition of the Supreme Court in the US. And some of my colleagues, the legal scholars, advise against going to the Supreme Court in the US, which does not mean that there is no hope in lower courts or in district courts. I don't know what's your feeling about that. The other aspect I want to underline for our audience, and then I'll ask our speakers to respond maybe or to develop, is that you have different types of organizations. And so traditionally, the US system is a bit more adversarial, and class actions and collective actions succeed in courts to bring about social change. And this is a great tradition that comes from the civil rights movement. And they have that, which is great and has inspired many people. In Europe, the case of Marjan is interesting of Urgenda, because they're not only controversial, they're not only litigating, they're also advising the government. So this opens up a very interesting perspective, I think, in terms of what you can do in court. It's not only demanding and being a claimant for yourself or for the public good, but it's also helping the government, which is notoriously overwhelmed and sometimes does not have the know-how. So it's a very important function in our democracy that these courts have, but they can act if they have the support of international law, or if judges are enlightened and have read climate science. What would you like to add to that? Maybe Phil, Marjan, Nathan, and Mia, who wants to? Yes, Nathan.
If I can start off.
Ah, sorry. Yes, Philip.
And what I'm going to do is share my computer here, sorry, there we go. What we got to do, what I want to do, I apologize that can you all see my screen now?
Yes. Your sound is a bit broken, though.
Pardon?
The sound is a bit broken.
Is this better?
Yes.
Okay, so in the United States, as we've talked before, Juliana is going after the fossil fuel energy system. And there are numerous historic examples of litigation that have had broad structural and systemic remedies. The obvious is civil rights litigation, primarily school desegregation. But we have other examples in the Pacific Northwest. There's been lengthy litigation over salmon rights and other treaty rights. There's public housing desegregation in Chicago. And then there's the California prison reform litigation, where the Supreme Court affirmed a target once the finding was that California's prisons were over 200% overcrowded. The California prison system was given a target to reduce the overcrowding to 137.5%. Otherwise, they were going to release prisoners. And the point of all this is Juliana currently is on interlocutory appeal, and the Ninth Circuit has said that federal courts, and I'll talk about this a little bit more later, but I want to introduce this topic. Federal courts cannot address climate change because any remedies that they would order would be outside of the role of the courts under Article 3 of the United States Constitution. I'm just going to say this one more time. The federal courts cannot issue remedies according to the recent Ninth Circuit opinion in our case, because it's outside the role, even though the evidence shows the federal government is harming citizens, including these 21 youth plaintiffs. And with that, I'll stop.
All right, thank you, Phil. Nathan.
Yeah, sure. I was just going to kind of bring up an interesting point that I did see as kind of a case of two very different legal systems, because something that is kind of unique to Juliana in that we're working within the US system is that we are very clear about where we kind of, draw the line with regards to separation of powers in the Constitution in the United States, where we say, here is the scientific mandate, 350 parts per million by the year 2100, and we have our 21 experts in their fields that will testify to that effect pro bono. But we stop there. We say we want the court to order a national climate recovery plan, but we say here is the mandate instead of advising the court on how do they get there. And what you've seen there is there's a new sphere in the United States with programs like the Green New Deal, for example, that are kind of at the same time being brought forth as possible, remedies that the legislative branches in the United States have the ability to take, from a slew of different options. But it's kind of an interesting distinction I see with the case in the Netherlands.
Oh, that's not really true. I think maybe I didn't explain it well enough. The court case is only about what the government for 10 years in a row has signed in numerous treaties and so on. That is between 25 and 40% reduction. In the court case, we didn't talk about any solutions, and we also told the court, the government does not even have to make a law to change it, because there are lots of things they could do. We are not going to tell what, because that's up to the government, but we only asked for the 25%. That was all, because that was what they had agreed on before the Paris Agreement in IPCC and Conference of the Parties and so on. And thereafter in European law and in Dutch policies and so on. But on the side of that, we informed the government, if you don't have any idea, we are willing to help you. So that was a part of the whole court case. So we offered in a separate session to the government a book with 54 different solutions with 800 organizations, but it was deliberately not a part of the court case, because you cannot ask them to do this or that or that. That's not our role. You can also not demand that a law has to be made. So we were very clear in showing that there were many examples in the Netherlands where the government could still do 25% without making a law, and that we were not telling them what to do. But in case they had any problems of finding solutions, we were open to help them apart from the court case.
Right, sorry, yeah, my mistake. I didn't mean to say that you were telling the government to do something which would violate indeed the separation of the three powers. But I wanted to highlight that some, even going to court, which is perceived as conflictual or adversarial, can also lead to further cooperation separately and afterwards. And this was a compliment to your way of doing things in the Netherlands, which is of course traditionally more consensual and collaborative than in our US adversarial system. But yeah, and thank you for specifying, Marjan. Mia, would you like to add something to this?
Just to say that in Norway, when we kind of the first two rounds of the court case, or especially the first round, there was a lot of attention in kind of the Norwegian debate surrounding the court case, was that the government viewed it as undemocratic to go to court. They meant that we were kind of, we were going past the democratic organs and kind of past the point where we're giving them our suggestions and going straight to court. And this is actually part of their official argument in court, that it's undemocratic to go to court, which is crazy because we have checks and balances in Norway as well, and we believe that going to court is highly democratic, especially when the government and the state are ignoring the science, which I think that our children's trusts are very good at speaking about, because it's a very important part of our court case as well, the specific science. And the only witnesses we have in court are scientists, climate scientists, which don't give their opinion, but they just kind of present the facts. And the fact is that stopping Norwegian oil production, or at least reducing it in longer term, will help the climate immensely, way more than any other cuts we can do in Norway. However, the democratic part of this has kind of, that debate is stopped because the court, both rounds, agreed with us and said that it was highly democratic. So now we have more of a debate surrounding kind of, should we shut down the oil industry? How should we do that? And is this litigation a part of doing that, which is much more productive debate.
Okay, well, thank you. Does anybody, Marjan wants to add something, and then we'll move on to the audience questions, which are already piling up in our chat. Marjan.
Well, maybe for the audience, it's interesting to know that there's many similarities, and everything from our case is also translated in English. It's all on our website. And this, what Mia just said, that it would be not democratic to go to court, was one of the main arguments of our government too. And the Supreme Court has made a very nice, in English, way of explaining why it is extremely democratic to go to the court, because you as a citizen can go to court to protect yourself from a government that is not taking its duty of care. And I think there's much material in our court case that maybe is helpful for you or anybody else. Everything is in English as well.
All right, thank you very much. So let me go over a few questions which have arrived already, and we might also give the floor to the audience. So I have 3 questions which are interesting right now. One is a general question, and I think it highlights an important point. So I would like to let you answer that. A question from Miles Rappaport. Miles, do you want to come forward, or should I ask your question? So Miles' question was, has the Paris Agreement changed all of this? What was the impact of the Paris Agreement? Do you want to answer that? I can, yes, Nathan.
My perspective on the Paris Agreement is that it is an extremely important component of, global kind of transnational workings on how we're going to kind of coordinate our systems to address climate change. At the same time, though, we do recognize that the Paris Agreement is a political product. And so the benefit of using the court systems is that, the court has more enforcement power, and it is not a political process. If you present, science with a specific target or a specific mandate in it, and the court, accepts that evidence, then, what the court says goes, versus, countries when they're lobbying at the international stage also have their own interests, of course, and their own constituencies, and those kinds of things that they also have to consider. And so that can sometimes lead to, targets that aren't as ambitious, or kind of making sure that they don't do too much so as to, not be in alignment with the rest of the world. But with that said, I think the Paris Agreement is definitely an important work.
To follow on one point Nathan made, the science before the court will not be, I'm going to call it, tainted by what political considerations. So if you talk to a climate scientist, the climate scientist will say to you, the Paris Agreement doesn't go far enough. The Paris Agreement is a political document, as Nathan said, and it satisfies various nations' purported agendas. But if you talk to a scientist, particularly if you put that scientist under oath and with testimony before a court, they will tell you that you have to do a lot more than what the Paris Agreement calls for in order to effectively stop the climate crisis for the youngest and future generations.
Right. If I can add here that the Paris Agreement is indeed a political non-binding document, but the good side of this agreement was that it provided a common language to everyone, targets, a language that sometimes the governments didn't have. And it was actually the transposition of the Paris Agreement or not in national law, which is crucial for plaintiffs and litigants to find grounds to act. And this is why Marjan's case is interesting. It has to become first a democratically owned thing, like passed in parliaments, in the political system, to give more grounds to act. Otherwise, it can be a bit elusive. It's true. So we have a question for Mia from Ashkai Dixit. Ashkai, are you willing to come forward and ask your question, or should I ask it for you? Yes. Hi, Ashkai.
Yeah. Hi, my name is Akshay. I'm a PhD student at the Kennedy School. Mia, fascinating to hear about your work. I just wanted to learn more about nature and youth. How do you communicate with other young people in your community, and how do you involve them in your work?
I love this question because I didn't have enough time to talk about it. So Nature and Youth is organized in local chapters. So kind of the most important part of the organization's work is the work that's done all over Norway by small local groups. And they're often like 16 to 18 years old. They're usually, or like 14 to 18 years old. And what they do is they kind of work with climate action and also just as much kind of nature preservance in their local communities. So they advise local politicians. They have demonstrations. They have anything that you could think of doing kind of in the name of activism for the climate. They do, and also contribute to debates in newspapers and online. And they have seminars and they often also have like social gatherings and meetings. And then we also have the central board, which is where I am, which kind of helps the local groups work, but we also have our own political work. So the climate litigation is a part of that, but we also work with transport and with the fishing industry and the fish farms in Norway, because that's also a massive industry. And in those two sectors, we kind of work more kind of positively, or we work with more solutions rather than things we have to stop. So yeah, that's kind of how we work. And then we do a lot of like social stuff in order to inspire and keep our activists active. So we also kind of, my last point that I should make before I use all my time is that we kind of do everything that we're able to do for the climate, except for, of course, violence. So climate litigation is kind of the last step for us, the kind of a last resort, because we've already been through all of kind of the advisement and the hearings and the debates and everything. So this is kind of like a last democratic solution to fix Norway's problem.
All right, thank you, Mia. So we have more questions coming, and thank you very much for your excellent questions. I'm sorry I won't be able to address all of them by the end of the hour, but we can hang out and say more. So two questions I like to tie together. It's about, so one is from Liz Smith and the other from Joshua Forstenser. What is the most effective way to engage in litigation when you're not directly affected by the question? It's the question of class action. So I tie this question to Joshua's question, and it's mostly addressed to Phil. So Phil, you might address those two questions. Can we expect a multiplication of class action lawsuits in the USA in the coming years against the large corporations responsible for most GHG emissions? Or is this a hopeless strategy? And bear in mind that you're also answering to Liz Smith, who asks, it's an organization question, how to litigate when you're not directly affected? So the question of class action and of collective organization, basically. Phil, what's your?
So the first issue in the United States is a plaintiff to bring a case has to have what's called standing. And to have standing, you have to show you've been injured by the conduct of the defendant, and the court can do something about it. So when it comes to standing in cases against various governmental bodies, you have to be able to show that you were injured, directly injured. And our plaintiffs have been able to show that. The Ninth Circuit, in our case, found proof of injuries. But if you don't have proof of injuries, not just physical injuries, but injuries to your property, to your mental health, these are all injuries, but you have to show injuries. In terms of class action, the problem with a class action in climate change context is what we call certifying the class. You have to be able to show that there is this class of people who all have been similarly affected. There has to be what's called commonality. And that's going to be very difficult to show in a class action context, which is why if you look at what are called the nuisance cases, cases where governmental bodies such as the city and county of San Francisco or the city of Baltimore or Boulder, Colorado, are bringing cases for damages against specific fossil fuel companies in their individually, as opposed to on behalf of all municipalities across the United States, because it's very, very difficult to show commonality, common damage caused by the defendants.
Right. Okay, we have another question from Harry Justice, who asks the Juliana Case panelist, how have you seen systemic inequities and systems of power in the US intersect with your case? And do you see an overlap to try to address systems of inequity while also addressing environmental issues? So I summarize this, it's about environmental justice, right? How would you like to address that? Nathan, I think you could answer that.
So in the case, in what I can speak to in Alaska, there's actually two very distinct sides to environmental justice that I think can both be addressed very much in tandem, but are not often thought of in the same spheres. One of those issues is the issue of, indigenous culture and the fact that we as kind of colonizing people in the United States came to Alaska, and when we bought Alaska from, Russia in 1867, there were already, thousands and thousands of indigenous people living here. And what that also means is that their culture is, founded on the sense of place. And so I'm not going to go deep into that because I do not have the perspective or the know-how to speak to that. But I will say that, in my own work on the ground in Fairbanks, I work very closely with a lot of those perspectives. And there's a lot of leadership from indigenous peoples in the climate movement in Fairbanks, which has been incredibly important in how it relates to Alaska. The other side actually is that in my own immediate friend group, close friends that I've known for years and years, some of them do not actually believe in climate change, which I'll just say is kind of it seems a lot like a US construct sometimes, because it seems like a pretty unique thing to the US that we're still debating whether there's climate change or not. But even in my own friend group, that is still very much a debate. And yet, when I take a step back, what that really stems from is the fact that, about 90% of Alaska's state budget, our general unrestricted discretionary budget, comes from oil royalties and oil taxes, because we are the only state in the United States that does not have any state income tax or sales tax. And so what that means is that we have this paradox of being, potentially the most affected state in terms of our climate region in the United States, and also the most indebted in the oil industry. And so when I look on my own neighborhood, I can look out the window right now, and I'm looking at a house where the wonderful family that lives there is a laborer for the oil industry, or the other guy across the street owns a construction company. And so I think there are two very key issues here. One is the issue of labor justice, bringing workers along, and I think there have been a lot of really positive proposals, certainly in the U.S. lately, that I could speak to on proposals that would bring workers along and make sure that this is what we call here a just transition. And then the other side of that is really recognizing, really indigenous wisdom around how to live in right order and right relationship with the earth that has been, discounted and kind of left out of the conversation for a really long time.
Right. Thank you, Nathan, for your answers. So
Do I
since
have to add quickly to that? Or?
Yeah, well, I wanted to end with, yes, Mia, can you take 30 seconds, then we'll end with a kind of global question.
I'll really try. I just wanted to say that the last thing that Nathan was talking about is just so important, because it's the part of climate litigation, especially when it comes to like trying to stop specific oil projects that we never have time to speak about, which is just transition, because we believe that if the government would actually do something about the climate issue and actually make a plan in order to stop the oil industry over an amount of years, then they'd actually be able to make a plan for these oil workers. And also, like, it's the exact same situation in Norway, only in Norway it's everyone is kind of tied to the oil industry personally. So it's really important that you brought that up.
All right, thank you, Mia. So apparently our official time is up. We had an interesting question on the effect of the pandemic on all this. I think the pandemic highlights in a crucial manner that there are trade-offs, difficult trade-offs to make between public health and the economy, but that social and economic effects can be pretty destructive. And the question of the just transition precisely is one that ties up nicely those questions, very complex questions. So I thank you all for joining today. Those who have to go, please do so. We won't be offended. The recording will stop at 1, and our co-host technical support will also end, but I'm gonna hang out, stick around, and you're welcome to do so for an informal chat with our panelists who have a cutoff time at 1:30, but like we can, let's say we have 20 minutes to pursue the conversation if we so wish. Thank you again, all of you, for attending this first seminar of the Green Democratic Leaders.